Greetings. Today, I, Abhilasha Yadav, an intern at ubAdvocate, is going to talk about a very important concept of constitutional law, that is, the Doctrine of Eclipse. According to this doctrine, an existing law, that is, a law made before the commencement of the Constitution, remains eclipsed or dormant to the extent it comes under the shadow of the fundamental rights it is inconsistent with. This doctrine emanates directly from Article 13(1) of the Indian Constitution, which states that all laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, that is Part 3, shall, to the extent of such inconsistency, be void. This means that a pre-constitutional law inconsistent with the fundamental rights is not completely void or null, but that it remains unenforceable, that is, it remains in a dormant state. Such a law is also good for all past transactions or rights and obligations arising or the liabilities incurred before the commencement of the Constitution. Further, it will still be applicable on individuals who have not been given the fundamental rights, for example, non citizens. Therefore, the impugned law remains hidden behind the fundamental rights and can become operative again if and when the inconsistency or the prohibition brought about by the fundamental rights is removed by way of a constitutional amendment. It is generally agreed that the actual genesis of this doctrine was laid down in the landmark case of Bikaji Narayan Dhakris versus State of Madhya Pradesh, which is a Supreme Court decision of 1955. In this case, the CP and Berar Motor Vehicles Amendment Act 1947 was challenged for being violative of Article 19(1)(g). It was an existing state law that authorized the state government to exclude all private motor transport operators from the field of transport business. Part of this law became void on the commencement of the Constitution as it violated Article 19(1)(g) and could not be justified under Clause 6 or under Article 19. However, in the year 1951, by virtue of the first amendment of the Constitution, the government was permitted to monopolize any business, and hence the act ceased to be unconstitutional and became operative and enforceable. According to the court, and I quote, the effect of the amendment was to remove the shadow and to make the impugned act free from all blemish or infirmity. Further, if we talk about the application of this doctrine on post-constitutional law, Doctrine of Eclipse has been extended to post-constitutional laws too, with the precedent laid down in state of Gujarat versus Ambika Mills Limited. It was noted down by the court that just as a pre-constitutional law taking away or abridging fundamental rights under Article 19 remained operative after the Constitution came into force as regards to non-citizens because it was not inconsistent with their fundamental rights, so also a post-constitutional law offending Article 19 remained operative as against the non-citizens because it was not in contravention of any of their fundamental rights. Further, the court also remarked that the meaning of the word void is same in both Article 13(1) and Article 13(2), and for that reason, a post-constitutional law which takes away or abridges the rights conferred by Article 19 should be operative as regards non-citizens. Basically, such a law is only void to the extent of the contravention of the rights conferred to citizens. This voidness is not in rem, but to the extent of contravention to the rights conferred by Part 3 of the Constitution that deals with fundamental rights. If a law is otherwise and does not contravene any of the fundamental rights, non-citizens cannot plead that the law is absolutely null and void and inapplicable to them just because it is inconsistent with the rights of the fundamental rights of the citizens. Therefore, to conclude, Doctrine of Eclipse is applicable to pre-constitutional law as well as post-constitutional law, and according to this doctrine, any law remains eclipsed or dormant to the extent it comes under the shadow of the fundamental rights it is inconsistent with. However, such a law becomes enforceable once the prohibition by the fundamental right is removed by way of a constitutional amendment. Thank you.